One of the most important and indeed most controversial issues in all of American history is the relationship between the Constitution and the American Revolution. For most of the modern period, starting with the Progressive era at the turn of the 20th century, American scholars have been divided over that issue. The progressives, people like Charles Beard, Vernon Parrington, argue that the Constitution was a counter-revolutionary movement, that the revolution was a kind of democratic, egalitarian movement, and the Constitution was an effort by elites to stem the tide of that revolutionary movement and basically rein in the radicalism of the American Revolution. So the question is, which of those interpretations makes better sense of the evidence? And of course, as you would expect, there's a certain amount of truth in each of those interpretations. The first thing to recognize is there's not one American Revolution. There are multiple experiences in the Revolution. So if we take Pennsylvania as our model, Pennsylvania is a very egalitarian and democratic revolution, but it's an interesting one because they also disenfranchise a huge percentage of their population. Loyalists, Quakers, people who did not side with the revolution. So they're very democratic, but they're also very exclusionary. We tend to think that democracy should be inclusionary, so even if we use Pennsylvania as a model of the most radical experience of the revolution, it's not a kind of democracy that I think many of us are completely comfortable with. There's also the question of slavery, which of course is a big one, and of course there's not one single response that the revolution has with regard to slavery. The revolution put slavery in New England that after the American Revolution, slavery in New England is essentially over. The Middle Atlantic, particularly New York and Pennsylvania, turned to gradual abolition schemes, which will eventually put slavery on the road to extinction. And of course, in the South, slavery remains a vital institution, but at least in the Chesapeake region, it is easier to manumit your slaves, which is to say to free them. And of course, some prominent Virginians, including George Washington, do free their slaves. Thomas Jefferson, of course, only frees the Hemmings family, which we could talk about because it's a fascinating subject, but a subject for another day, perhaps. Now, so we have, with these new state constitutions, a predictable human situation, which is having experienced a strong government, most of the states enact much weaker kinds of government. So, for instance, the executive, the new governors of these state governments, much weaker than the strong monarchical form of government that England has. The Articles of Confederation, the first effort to have a national constitution, doesn't even have a proper executive. It has a committee, and the head of that committee is called the president, which is where we get the name for our head of state, our executive. So, and the Articles of Confederation decides that because the powerful Parliament had enacted all these onerous taxes, they will not give this new government the power to tax. And of course, trying to imagine how you're going to fight a war and how you're going to have a government without the power to tax is an interesting question. So, in terms of understanding the revolutionary experience, there really isn't one revolutionary experience. There are multiple strains coming out of the revolution, and not all of the experiments that the revolution inaugurates are entirely successful. So to understand the Constitution, we need to understand how it is a reaction not so much against British tyranny, although that is still on people's minds. It is primarily a reaction to the Articles of Confederation and indeed to some of the problems that are occurring under the state governments. So what are those problems? So the problems that beleaguer the new Articles of Confederation and the state governments take several different forms. I've already talked about the problem about taxation. The Articles of Confederation does not have the power to tax. There isn't a federal judicial system to handle some of the legal conflicts that arise in a confederated republic. And of course, the individual state governments are doing things that at least several of the people who we generally think of as our founders of our constitutional tradition are deeply worried about. So let's take James Madison, for instance, who many would call the kind of architect of the Constitution. Madison is a really studious, intellectual kind of figure. He writes to Jefferson, who is in Paris, and asks him to comb the Parisian booksellers. Paris, of course, to this day is one of the great publishing cities of the world, along with New York and Amsterdam. And he says, find me everything you can written in French, English, or Latin on the subject of republican government, the history of republics. And Madison, the good student that he is, and we can actually see this because we have Madison's papers at the Library of Congress, takes a kind of commonplace book. That's an 18th century notebook where you write down things that are interesting or important and you take notes, you commonplace them. And most of the founders had commonplace books where they transcribed and sort of processed their thoughts about things. And Madison systematically goes through essentially the great republics of antiquity, and he kind of identifies what the strengths and weaknesses of each of their historical and political history was. He then sort of distills that into a kind of memo, kind of an extended outline, if you will, which we call by its description in Madison's papers called The Vices of the Confederation. And in that he tries to apply what he has learned from history to what is going on in America. And he notes that there are several problems with the governments of America. Many of the state constitutions were not actually voted on by the people directly. They were ad hoc efforts by legislatures to create governments in the midst of a war. So, I mean, we can't really blame them. They were in a dire circumstance. But if you think about it, Madison comes to believe, and it is a remarkable step forward in the way you think about law and constitutionalism and liberty, that any government that is going to be the supreme law of the land, that is going to state the fundamental principles of government, has to be approved by the people directly. And so he comes up with this idea that we must have ratification conventions, that we must submit constitutions to the people. Because constitutions, in Madison's belief, are going to be superior to anything an ordinary legislature does. What the Constitution does, the legislature cannot undo. The only way you can undo something in the Constitution is you have to amend that Constitution. And that has to require an extraordinary consensus among the people. So that's one insight that Madison comes to, that although these constitutions have served us so far, we need to actually now go through a process where we go through these state constitutions and we put them on proper footing. And indeed, several states revised their constitutions in the 1790s, Pennsylvania, for instance, being the most prominent example. Now, Madison also notes that several of the states have been enacting laws that are just not fair. And what are those laws? Well, basically, they've been enacting debtor relief laws. They've been making it much harder to collect debts. And Madison believes that, that he recognized that during the American Revolution, sometimes the government had to print money and they had to use inflation to pay for the cost of things. But as a general rule, he comes to the conclusion that a policy of inflation obviously benefits debtors at the expense of creditors, and he doesn't think that that's fair. So he wants to make sure that under a reformed constitutional government, you can't use, majorities can't use the power of government to oppress minorities. Eventually, what emerges from this little Vices of the Confederation memo is arguably the most famous statement of American political thought, the 10th Federalist, which Madison writes under the name Publius, again, a kind of Roman reference to a great leader of the Roman Republic. And the Federalist is written to defend the United States Constitution against its anti-Federalist critics and to explain the Constitution. And to this day, it still functions as the most important oracular text to help us understand the meaning of the Constitution. A friend of mine, law professor, says he oftentimes thinks, oh, the Federalist, that's the user's guide for the Constitution. That's the manual they forgot to include in the box when they gave us the Constitution. So what does the argument of the 10th Federalist say? The 10th Federalist is Madison's effort to understand one of the most basic problems of political life, and one that the Constitution seeks a unique solution to, and that is the problem of faction. If you recall, the Revolutionary era was very concerned about political virtue. They wrote it into their constitutions. They had come to realize by 1787-88 that if you put all of your faith in virtue, you were likely to be disappointed, because the idea that any political body could consistently act in a virtuous manner is simply not realistic given human nature. So Madison, looking over the history of ancient republics, looking over the recent history of America, says, is there any way we can artificially or creatively come up with a solution to deal with faction? Because in essence, what is corruption? Corruption happens when people put a narrow interest ahead of what's good for for their society. Corruption happens when people manipulate the system to benefit themselves at the expense of others. Madison comes to believe that many political philosophers, going back to the great ancient philosophers, going back to Aristotle, through the Renaissance philosophers, through the great English philosophers of the 17th century, Locke and Harrington and Sidney, they have all failed to grasp an essential point of politics, which is you must build political solutions around the real nature of humanity, not around some idealized hope about humanity. And Madison recognizes the one thing that you can count on in most circumstances is that people will follow their self-interest. Now, if people follow their self-interest in a kind of everyone is out for themselves, that's anarchy. That will not result in a good outcome, particularly when there are unequal resources available. So, for instance, Madison is particularly worried about that majorities will oppress minorities, that they will sacrifice the interests of either religious minorities and oppress them, or property holders who are a smaller group, at least large property holders are a smaller group than average property holders. He's worried that perhaps they will get together and oppress through these pro-debtor kinds of legislation, creditors. So he recognizes that that is a dynamic in politics, and that leads to conflict, that leads to corruption, and ultimately that can be the downfall of a republic. So his insight is, how do we make interest work for us instead of against us? And theorists, going back to throughout the Western tradition, have thought that a republican government will only work if the republic is small and everyone has the same interest. So a small agrarian republic where people are ethnically, racially, religiously homogeneous. That's the only way that you can have a republican government, because everyone is basically very similar. They won't fight incessantly over how to allocate resources. They won't fight over religion. They won't fight over which sector of the economy needs to benefit, because they're all farmers. Madison says that's mistaken. And you have to think about this for a moment, because in a way it's breathtaking. Madison, after studying ancient history and looking at the recent history of America, says all of Western political thought has got it wrong, and I have figured it out. It is one of the great eureka moments in modern political theory. He says, in fact, the opposite is the case. Now, and to be fair, he has read David Hume, who has helped lay some of the foundation for this line of thought. But he says a big republic, a republic of multiple interests, where the interests are constantly realigning and where no one interest can dominate, that is a much greater check on corruption and tyranny and factionalism than the small republic. I like to think of Madison's vision of politics as a kaleidoscope. It's like the kaleidoscope changes and the alignments change, and therefore you can't have permanent fixed alignments where a permanent fixed majority will permanently oppress a single minority. One day, coming from New York, New York's history is great this way. So one day Italians are aligned with Puerto Ricans in the Bronx. The next day it's Orthodox Jews in Crown Heights who are aligned with Koreans in Queens. And it is, in fact, New York's diversity and the constantly shifting alliances that mean that no one group permanently runs New York politics. So the more multicultural, the more diverse, the more economically complicated your society, the less likely you will succumb to this problem of faction. In fact, faction will be channeled in a way that makes it artificially produce a better outcome than you could hope for, unless you had the perfect philosopher, king, the perfect virtuous leader to rule over you. And of course, in Federalist 51, Madison further develops the theory, noting that unfortunately, and I'm paraphrasing now, of course, if angels governed men, we wouldn't need government or constitutions. And he famously says in that, talking about the separation of powers, how do you protect people from the government becoming corrupt and tyrannical? He says, you build in a situation where the ambitions of each branch of government lead them to check the ambitions of the other. So that's why we have a presidential veto, we have a congressional override, Supreme Court, we have judicial review. All of these things are designed so that the political ambitions and self-interest of each of the branches is a potential check on the other branch getting out of control. In some ways, some have argued that, in fact, the founders actually designed their system all too well, because most people, at least at this particular juncture, seem to think the system is much better at clogging and preventing things from happening than it is at facilitating rapid change to deal with extraordinary circumstances. Parliamentary governments, you just form a new cabinet, you have no confidence in the prime minister, the coalition reforms, and you get on with it. But our system, in a way, is designed with this fear of corruption and tyranny so deeply embedded that what our system does best is actually prevent things from happening. And of course, the real challenge is the founders did not believe, they had no naive faith in government, but they were not anti-government either. They were good Whigs, good Republicans who believe that if you put too much faith in government, you'll be disappointed. If you don't endow government with enough power, you're left with the chaos of the Articles of Confederation. And of course, the Constitution is designed to be that happy medium that gives you energy without tyranny. And it gives you liberty, but liberty without anarchy. And that, of course, is the genius of the system. And of course, today we're trying to figure out, are there any little tweaks we can do? And are our politicians sufficiently well aware of what this constitutional tradition is supposed to do? Are they actually living up to their obligations under it? And one sometimes wonders whether they actually understand our constitutional tradition. So your job as teachers and students is to educate them. I think many Americans find it hard to believe that there was an opposition to our Constitution, that in fact it wasn't a foregone conclusion we would get a Constitution. It was a very controversial process, the ratification process, where each state held a special convention and they sent delegates and they decided up or down, single up or down vote. And it was close in a lot of places, and had a few things happen differently, the Constitution might have been rejected. I think it comes as a big surprise to people that this Constitution, which we now all venerate, was a controversial idea when it was first proposed. So who were these people who were against the Constitution? Well, they were never very happy with their name. The Federalists, and we like to say that the winners often write history, the Federalists called them Anti-Federalists, and of course they felt like they were true Federalists. They believed in a confederated form of government. One Anti-Federalist, when he served in the first Congress, quipped that if the Anti-Federalists had won, and since the battle was a struggle over ratification, perhaps the two names should have been rats and anti-rats. But again, since history is written by the winning side, in this case Federalists, we talk about Federalists and Anti-Federalists, not rats and anti-rats. So among the Anti-Federalists, the ones we're most likely to know today are people like Patrick Henry and George Mason. Virginia produced a very impressive group of Anti-Federalists. And of course, their opposition to the Constitution stemmed from a commitment to states' rights, to a fear that a powerful federal government would be tyrannical, to a belief that only a government that remained fairly close to the people could be properly checked. and that we were going to try something that had never been tried before and was likely going to fail, and the risk was too great to adopt this Constitution. And of course, one thing that many people were concerned about was there was no Bill of Rights. I mean, if you'd ask many people today to name part of the Constitution, probably the only thing they would be able to name would be some aspect of the Bill of Rights. Yet that wasn't even part of the Constitution when it was originally proposed. The Federalists, the people who defended the Constitution, argued that this new Constitution only had powers that were given to it by the text of the Constitution, so-called enumerated powers. Therefore, it simply wasn't necessary to have a Bill of Rights. That was what James Wilson, one of the greatest lawyers in America, a prominent Federalist, said. And then, of course, Alexander Hamilton, in the Federalist, written with James Madison and John Jay, published in the New York newspapers and eventually published as a book, he argued that, in fact, not only is it not necessary to have a Bill of Rights, it would be bad to have a Bill of Rights. His reasoning is you can't list every right that you want to protect, and by listing some, you will, by implication, exclude those you haven't protected. So therefore, it was a bad idea. Now, if you think about it, many Americans today, one of the rights that most Americans think they have, and the courts certainly have defended this right, and I think most Americans do believe it's a fundamental right, is privacy. But the word privacy does not appear anywhere in the Constitution or the Bill of Rights. And in a way, Hamilton would say, see, I told you so. You know, everyone values privacy, yet we forgot to put it in there. Now, obviously, privacy has evolved under our jurisprudential tradition in a series of cases. But when those cases were decided, they were controversial because several of the justices, the most famous being Griswold versus Connecticut, the case that really establishes the modern right of privacy, several of the justices said, you know, if I was a legislator, would strike down this law or repeal it, or I believe privacy is very important, I would enact legislation to protect it, but it's not in the Constitution, and therefore as a judge I can't really find it in the Constitution if it's not there. So the problem of the Bill of Rights is really quite complex, but it does become one of the central issues in the debate over the Constitution. Ultimately, of course, obviously the Constitution triumphs. There's some compromise. And the key compromise is in Massachusetts, which has a debate, a ratification convention in sort of the middle of the process. And at that point, the Federalists have argued against the Bill of Rights long enough that they realize it is just such an important issue to the American people. They can win over modern Anti-Federalists if they concede. And so they say, okay, we will, once the Constitution is adopted, take up the issue of amendments, and we will protect fundamental liberties, such as freedom of religion, freedom of the press. And the Bill of Rights is, I think, a remarkable part of our constitutional tradition. Interestingly, James Madison thought that the Bill of Rights wouldn't really do very much. And yet, ironically, in the first Congress, he becomes the person charged with sifting through the more than 200 suggestions for amendments and whittling them down to about a list of 20, which Congress further whittles down to 12. The first 2 are not adopted by the states, and we're left with the first 10, which we now call the Bill of Rights.